Okay, we're starting part 3 of the reading of Weiss's Concise Trustee Handbook. This is Jenna Scott, your host, and we are going to continue on with learning about certificates. What may come as a surprise is that any trust may divide its trust property into shares and issue certificates. Footnote 34. The power to issue certificates and bonds and employ the use of an official seal, footnote 35, never has been restricted to corporations, footnote 36. It is well settled law that whatever else most corporations possess beyond their artificiality and right of suit in a corporate name is a mere incident or consequence of incorporation and not a primary constituent. Footnote 37. In fact, most attributes now commonly held as corporate in nature, such as the power of issuing transferable shares, limiting liability of officers, using an official seal, making bylaws, purchasing lands and chattels, are merely the legislative recognition and adoption of natural common law rights any man or woman, sui juris, may exercise without permission, much less a charter from the state. The court in Warner versus Beers, footnote 38, clarified this principle most effectively. And there's a quote here from that case, and it says, there are several very useful and beneficial accessory, and says it's also, in brackets, also spelled accessory, A-C-C-E-S-S-A-R or A-C-C-E-S-S-O-R. I pronounce that accessory, so that's how I'm going to pronounce it. So let's start again with the case. There are several very useful and beneficial accessory powers or attributes very often accompanying corporate privileges, especially in moneyed corporations, which in the existing state of our law, as modified by statutes, are more prominent in the public eye, and perhaps sometimes in the view of our courts and legislatures. Footnote 39. Than those which are essential to the being of a corporation. Such added powers, however valuable, are merely accessory. They do not in themselves alone confirm a corporate character and may be enjoyed by unincorporated individuals. Such a power is the transferability of shares, such too, is the limited responsibility, in brackets liability, so too the convenience of holding real estate for the common purposes, exempt from the legal inconvenience of joint tenancy or tenancy in common. Again, there is the continuance of the joint property for the benefit and preservation of the common fund, indissoluble by death or legal disability of any partner. Every one of these attributes or powers, though commonly falling within our notions of a moneyed corporation, is quite unessential to the legality of a corporation, may be found where there is no pretense of a body corporate, nor will they make one if all were combined without the presence of the essential quality of legal individuality. And then there's a note in brackets, italics, and bold emphasis and bracket information added. The trustee of an express trust is empowered by the terms and provisions of the trust instrument to issue certificates not only of beneficial interest, footnote 40, but also of capital interest, footnote 41. Generally speaking, beneficial interest is that which is held by the beneficiary of the trust, who is entitled to a certain proportional share of the trust assets during the life or at the termination of the trust, while capital interest is that which is held by the exchanger, who has invested property into the trust and thus becomes entitled to a certain proportional share of any profits and assets remaining at the termination of the trust. As a rule, the terms and provisions of the trust instrument control the manner in which beneficial and capital interest are to be administered. It should define the rights of interest holders who, incidental to their acceptance of the interest, are bound under the trust instrument to that extent. Footnote 42. But there are certain principles which govern these interests in construing the fundamental classification of the trust. For instance, it is held that where the certificate holders have control over the trust property and/or administration of the trust's affairs, the trust arrangement is, in fact, a partnership in which the shareholders become liable for the acts of the trust. Footnote 43. The basic principle is that if it is free from the control of its interest holders, then it is an express trust. Footnote 44. This is commonly referred to by courts of equity as the, quote, control test, end quote. Footnote 45, in which control must ultimately rest with the trustees of the trust in order for it to be properly classified as an express trust. The well-settled principle applied by courts of equity is that interest holders, by full legal title and control over the trust property, being vested absolutely in the trustees or trustee, cannot be considered partners nor agents, footnote 46, and therefore cannot be held liable for the debts of the trust in that matter, footnote 47. Page 10. Furthermore, the certificates have no determinable fair market value, and therefore no gain or loss is recognized until the cost or other basis of the property disposed has been recovered. Footnote 48. In Commissioner of Internal Revenue versus Marshman, footnote 49, the court held that fair market value is determined by property received by the taxpayer, not the fair market value of the property transferred by the taxpayer into the trust. What's more is that certificates are considered not necessarily as chattels, but as documentary evidence of ownership and intangible rights. Footnote 50. And in and of themselves, they are only personal property, footnote 51, not the actual interest or share itself, footnote 52. The interest in an express trust cannot be traded without the approval of the trustee or trustees. This is contrasted with the certificate of stock, which courts have long held may be dealt with in the market as a, quote, commercial document of value, end quote, footnote 53. Trustee basics. First and foremost, anyone, man or person, capable of taking physical possession of or legal title to property can be a trustee. Footnote 54. And there is no limit to the number of trustees who may serve in any one trust. Generally, where there is more than one trustee, the trustees with respect to each other are referred to as co-trustees, footnote 55, and when acting jointly as a collective body are referred to as the board of trustees. Furthermore, there is no law prescribing the character of a trustee, and while it has been held that a trust cannot be invalidated simply due to incompetence, the trustee should be at least someone capable and fit for executing the powers and duties honorably. Footnote 56. This is the basis for the general rule that beneficiaries are not desirable as trustees, though there is no law to forbid such appointment. Equity will generally avoid all temptation to a breach of trust. The trustee should be stationed within the jurisdiction of the court of equity in which the estate is located, if indeed the trust corpus is an estate. But where the trust corpus is portable land, the trustee need not be stationed within any single jurisdiction. Non-residency will not disqualify or preclude the trustee from carrying out his position. Footnote 57. As far as accepting the appointment is concerned, this should be done formally, expressly in writing, even though it will always be implied, quote, if the individual intermeddles with the trust property or performs any act to carry out the trust, end quote. Footnote 58. Once acceptance has been tendered, no court of common law or equity can prevent the trustee from holding that office except for breach of trust. Footnote 59. Or good cause dependent upon clear and lawful necessity. Footnote 60. Removal must be procured pursuant to the provisions of the declaration, or where no such provisions are made, by decree of a court of equity. Lastly, it should be noted that the office of trustee is not always a desirable one. When the trust instrument conveys a burdensome obligation, the trustee is miserable and at risk of breach by failure to perform. When the trust instrument has been constructed poorly, the trustee is miserably confined and inhibited, and he may well be held liable for trust contracts with outside parties. The trustee has a duty of care toward the beneficiaries, and must harbor no biases or resentment in administration. Therefore, it is prudent to empower the trustee with enough discretion to carry out his position to the best of his ability and responsible creativity. To put it plainly, the settlor must truly trust the trustee to carry out his duties and use his powers justly. Powers and duties of the trustee. The powers of a trustee are divided into three categories: general, special, and discretionary. The general are all those inherent in trustees' virtute officii, i.e., ordinarily conferred by trust law. The special are all those conferred by the trust instrument, and the discretionary are all those arising out of the necessity of personal judgment, though broad discretion may also be conferred by law and as well as by trust instrument. Footnote 61. It is well settled law that under a declaration of trust, the trustees must have all the powers necessary to carry out the obligation of that private contract which they have assumed. Footnote 62. Furthermore, it is settled that the trustees of an express trust are afforded greater latitude to carry out their duties than ordinary trustees. Footnote 63. The trustees are empowered to control every aspect of the trust according to the trust instrument and equity, and retain the power to remove even the beneficiaries from the premises, not from the trust. Footnote 64. These powers include, but are in no way limited to, the power to bind the trust in a contract, especially where such obligation is implied by law, footnote 65, and the power to contract with the beneficiaries, the power to partition, exchange, sell, pledge, or mortgage the trust property, either in whole or in part, footnote 66, the power to lease trust property, footnote 67, the power to issue, change, or otherwise dispose of securities of the trust, the power to support the beneficiaries in all reasonable manner, the power to prosecute and defend in the trust name or trustee's name, the power to make gifts out of trust property, the power to delegate all unessential powers and duties, and the power to exercise personal judgment and every discretionary power not prohibited by the trust instrument. Footnote 68. He may do whatever a man or woman may lawfully do according to natural right. The fundamental principle of law is that for every power there is a correlative duty. The trustee, as a fiduciary to the beneficiary, assumes certain basic duties outside of the management of trust property and other general duties aside from whatever specific duties may be conferred upon the trustee in the trust instrument. These duties include, but are not limited to, the duty to support the beneficiary in any essential needs which it may have out of the funds which would otherwise be paid to it in distribution. And if such funds are not available, the duty to accumulate any balance needed, footnote 69. The duty to refrain from taking advantage of peculiar knowledge or position when dealing directly with the beneficiary, the duty to exercise the utmost good faith in all concerns of the trust, whether dealing with the trust property itself or directly with the beneficiary in matters concerning the trust, footnote 70, including to care for, protect, and secure the trust property. The duty to preserve, protect, and further the trust's interests according to the purposes designed in the trust instrument, including pressing all reasonable demands and prosecuting and fending off all claims, and claiming all available exceptions and taking all available remedies and advantages in trust matters. When delegating unessential powers and duties, the duty to exercise at least a general supervision of the trust affairs and to perform any ministerial acts which require the exercise of discretion or judgment, footnote 71. The duty to keep minutes and separate accounts of the trust, even if kept in a book with other accounts, with minutes showing decisions and resolutions reached, and accounts showing the state of the trust and pertinent details of transactions, generally in the form of schedules of income received, income paid, additions to principal, deductions from principal, principal on hand, and changes in investment consisting of debtor and creditor sides, footnote 72. Upon acceptance of the trusteeship, the duty to secure and protect the trust property and trust documents, footnote 73. When investing trust funds, the duty to invest securely so that they shall be preserved intact for the remaindermen, and to invest productively so that they shall yield at least the current rate of interest to the life tenant, footnote 74. And finally, the duty to concur with all co-trustees except where authorized to act individually, footnote 75. Privileges and liabilities of the trustee. In addition to powers and duties, there are certain privileges, including allowances, rights, and liabilities of the trustee. These are all those which are enumerated in the trust instrument and naturally extended to the trustee of an express trust. As was noted earlier, certain restrictions placed upon trustees of ordinary trusts do not apply to the trustee of an express trust pursuant to the doctrine of greater latitude, footnote 76. These, aside from those allowed by the trust instrument, include, but are not limited to, the inherent, unquestionable right to full compensation, including reimbursement of all out-of-pocket and other expenses incurred in the discharge of duties. An unduly withheld reimbursement results in a lien on the trust for the amount plus interest. Footnote 77. The privilege of residing within the trust estate and allowance of rates and taxes, although he, the trustee, has the benefit of residing in the house. Footnote 78. The right to employ a solicitor, footnote 79, for assistance and guidance in the administration of the trust, and in the case of any doubt or difficulty, to seek the opinion of competent counsel, and, in the case where the trust accounts are intricate and complicated, to seek the assistance of an accountant to the charge of the trust. The right to apply to a court of equity for directions in the execution of the trust, or to obtain a declaratory judgment in order to establish the meaning and intent of the trust instrument. Footnote 80. The right to carry on in separate business for the benefit of the trust, given certain conditions. The allowance of remuneration for loss of time under certain circumstances. The right not to be compelled by subpoena or review to produce and show records or books to outside parties. Footnote 81. The right to further limit his liability in particular contracts, even beyond the limitation made in the trust instrument. The right to relocate, move trust property, or change the trust domicile. Footnote 82. And the inalienable right to disclaim the office at the execution or resign at a later date. With regard to the personal liabilities of a trustee, basically, the inherent liabilities and non-liabilities are all those incident to ownership at law, footnote 83, and imposed or exempted under contract law, for it is a maxim of law, le contrat fait la loi, footnote 84. Therefore, a trustee's liability is largely determined according to the particular circumstances of the situation, especially contracts wherein the trustee has properly limited his liability via qualified signature. I will discuss the principles of and procedure for properly qualifying one's signature in a later section. For now, we will entertain the general liabilities, which may include, but are not limited to, liability on all contracts made, whether signing as trustee or signing individually, footnote 85, liability of removal for breach of trust, waste, mismanagement, or good cause shown in an action for removal in a court of equity, footnote 86, or according to trust instrument. Liability for losses sustained by the trust as a result of negligence, footnote 87. Liability for torts and common law criminal and civil wrongs or acts of bad faith, footnote 88. Liability in all cases of commingling of trust funds, footnote 89, and finally, liability for all mischief of his agents contracted to exercise discretionary powers, footnote 90. But the trustee is not at all liable for any losses sustained in the proper discharge of duties, footnote 91, and in the case of other losses due to negligence or tort, the trustee may be able to be bonded in a manner ordinarily used for executors and administrators. They are generally not liable for contracts in which liability was properly limited using the methods to be shown later. Such contracts may also encompass the codes and statutes of various jurisdictions, given that all man-made law is by its nature fundamentally contractual. The debts of the trust incurred requiring the creditor to look solely to the trust for payment, footnote 92. Conversely, the trust is not liable for the personal debts of the trustee either, footnote 93, except to the extent of attachability of the trust's interest in the trust, footnote 94. The independent, non-preventable acts of co-trustees, of which he had no prior knowledge, footnote 95, the acts of his agents when properly contracted, taxes on the income of the trust, footnote 96, and finally, lawsuits against the trust. Authorized representatives. As shown above, it is well within the power, discretion, and oftentimes duty to contract an authorized representative, managing agent, or attorney-in-fact to deal with certain affairs of the trust. And the basic rule which courts of equity have laid down is that a trustee may contract such agents to handle all affairs which require no discretion, be they ministerial or not, and he may not delegate the essential part of a power unless, of course, he is permitted to do so by the trust instrument. In clarifying the discretionary power rule, it must be noted that there is no law against delegating discretionary powers to agents. The rule is simply that a trustee who does so, quote, does so at his own peril, end quote, footnote 98, for he is liable for all losses generated by the agent, if any. To clarify what constitutes the essential and unessential parts of a power, the essential part is defined as the exercise of discretion and determining of needs of the trust or the appropriateness of an action. The unessential part is that, quote, not requiring the exercise of discretion, end quote, etc., etc. However, there is a simple solution allowing for greater flexibility in this rule. The solution is to, quote, authorize the agent to contract on behalf of the trust, subject to the assent of the trustee, footnote 99. And as noted in the previous section, if the trust instrument makes provisions for the contracting of an authorized representative, then the trustee cannot be liable for his acts, footnote 100. Now, the method for contracting such agents may be either by formal appointment if mandated by the trust instrument, or by execution of a limited power of attorney, letter of authorization, or even certificate of verbal authorization documented by minutes of meeting. The most effective, secure method of contracting such an agent would obviously be an actual appointment with written contract setting forth the specifics of the position. But a letter of introduction is, for most purposes, sufficient, as is a simple power of attorney when the agent is acting specifically under the title of attorney-in-fact, footnote 101.